Mr. Speaker, it's a pleasure to follow the Honourable Lady. I will return to one of her points in a moment, but I will start by focusing on the amendments tabled in my name, Amendments 118 to 121. In 2017, we reformed pre-charge bail, that's police bail in the jargon, to introduce time limits on how long suspects could be held on bail before being charged, and we introduced a general presumption against the use of pre-charge bail. These changes came after the terrible treatment, and I reiterate that, the terrible treatment of some people, the most famous, I guess, of which was Paul Gambaccini and the spin-off from the Savile affair, whose career was destroyed, and the effective presumption of guilt, really, I think, in the treatment of him. Now, even with those 2017 reforms, we still see a large number of people on pre-charge bail today, and indeed for excessive lengths of time. In 2019, the number on pre-charge bail was 84,000. In 2020, it was 153, nearly 154,000. So the effects of the 2017 legislation is not to suppress pre-charge bail, and so the logic behind the changes in the current bill are actually flawed to start off with. But worse than that, the number of people held on pre-charge bail for more than 12 months is 2,344, itself an increase on the previous year. These are people for whom there is not enough evidence to charge. Not convict, charge, which is a much, much lower threshold. Now, I currently have a case where the National Crime Agency has kept an individual on bail for almost 6 years. That's 6 years of being unable to live anywhere but her home address. 6 years of being unable to see her family because her passport's withheld. 6 years without a bank account. 6 years without a job or career. 6 years unable to lead a normal life. And when I took it up with the National Crime Agency, I got a letter in response which frankly would have done justice to an episode of Yes Minister. But most interesting in it was a comment which said, they were making the point that investigations took a long time. Investigations of this length are not uncommon when dealing with complex cases. 6 years is not uncommon in a justice system where the presumption of innocence is paramount. That's the problem that I am addressing with my amendments today. For someone who's not even been charged, the NCA's actions in this case make a complete mockery of the principle of presumed innocent until proven guilty. And by the way, just as an aside on this, separate to the bill, we can't find out how many people the NCA has under this circumstance. It's not subject to FOI. We know nothing about its operations, and yet they still do these things. So today's bill seeks to undo the 2017 reforms, eliminating the general presumption against pre-charge bail and amending time limits. Now, while reform is clearly needed, this is not the correct way to do it. As the Law Society has said, changes to pre-charge bail may lead to people being kept in limbo for long periods of time, impacting their civil liberties. I entirely agree. The government, of course, argues that its proposed reforms have public backing, but the consultations responses were starkly skewed. Police and law enforcement agencies accounted for 65% of the responses, compared to the legal profession's mere 3%. So you shouldn't take too clearly, nobody should take too much at face value the government's claim that this reflects the consultation. It reflects the interests of the agencies involved. So my amendments 118, 119 introduce a 2-year absolute limit on the use of pre-charge bail. This will ensure agencies have time to investigate properly, but promptly. And remember, the test is the test of the ability to charge, not the ability to convict. That's how far you've got to get in 2 years. So that's the primary aim. Amendments 120 and 121 will stop the government from reversing the presumption against the use of pre-charge bail. This will prevent a return to the practice of bailing suspects for lengthy periods with strict and unacceptable curbs to their civil liberties. So that's my amendments. But if I may, I'd like to pick up the point made by the Honourable Lady, the spokesman of the opposition, because clearly she got some back pressure from these benches. And as it stands, this bill actually does pose a grave threat to the fundamental right of process that this country's had enshrined in our national fabric for, I think, some 800 years. The bill does address real issues, but the government wants to have the power to arrest people who cause serious annoyance or serious inconvenience. These are incredibly vague terms, frankly. It was clearly a breach of the normal reasoning behind a demonstration when somebody glues themselves to a train with a direct intention of inconveniencing everybody else. But demonstrations do lead to inconvenience. And so it hasn't just been the sort of lefty liberal legal fraternity that has been worried about this. There was a letter to the Home Secretary published today, or at least elements of it published today in today's Times, from a number of police chiefs who are concerned that what this does is twofold. One, it puts the police in the position of making judgments that they should not be making. It should be specified by this House, not by the police chiefs themselves. And secondly, effect of that is to put them in a politicised position. And that's really problematic. You know, we have an apolitical police, and every law we write must be written on the presumption that it'll be a government very unlike ours that oversees it at some point in the future. What if in 20 years' time we have an extreme right or an extreme left-wing government and we have this sort of vague issue in place? So I asked the front bench to pay attention to this, to the precision of it, to get it exactly right, deliver what I give way to the Honourable Lady.
Very grateful to the Honourable Gentleman for giving way. Does he agree with me that there's an incongruence between a government that says it wants to defend free speech in universities, but is effectively attacking the right of freedom of expression on our streets by criminalising activities that will cause serious unease?
He has a point. And
just to say, I really am up against the time. Just say, I want to hear a lot more free speech. David Davis.
I take your point, Mr. Speaker. I'll be finished in less than a minute. I was the person who brought the 10-minute rule bill, the precursor to the government's bill on this. Yes, but there is a balancing issue, but the House must be precise about that balance. So given the Speaker's injunction, I'll bring my comments to an end. It seems to me this bill does some important things, but it needs to get some things very much closer to right than they are now.